हरिः ॐ शन्नो मित्रः क्षं वरुणः शन्नो भवत्वर्यमा शन्नो इन्द्रो बृहस्पतिः शन्नो विष्णुरुरुक्रमः नमो ब्रह्मणे नमस्ते वायो त्वमेव प्रत्यक्षं ब्रह्मासि त्वमेव प्रत्यक्षं ब्रह्म वदिष्यामि ऋतं वदिष्यामि सत्यं वदिष्यामि तन्मामवतु तद्वक्तारामवतु अवतु माम् अवतु वक्तारम् ॐ सहनाववतु सहनो भुनक्तु सह वीर्यं करवावहे तेजस्विनावधीतमस्तु मा विद्विषावहे ॐ शान्ति शान्ति शान्तिः।
Namaskar and good morning, good afternoon to everyone. I would like to extend a very warm welcome to all of you to today's Vimarsh program, in which we are releasing the VIF's latest publication, Criminal Justice System, My Experiences and the Way Forward, by Advocate Devinder Pal Singh Ji. I would also like to welcome the author. Devinder Pal Singh Ji is a distinguished fellow with the Vivekananda International Foundation and has been associated with us for a very long time. And we have always benefited from his knowledge and advice on various issues pertaining to law and justice. So he's been part of our discussions on a variety of subjects for a very long time. And we are very grateful to him that he accepted the VIF's invitation to write this book, Criminal Justice System, in which he has looked at, which a book which is based on his experiences with the system over the last 30 years or so. Devinder Pal Singh Ji was Additional Advocate General of Haryana and Punjab states some years ago. And he represented the states before the High Court and the Supreme Court. He has also led prominent trials both as defense counsel as well as special prosecutor. And he has represented the CBI and the ED as a prosecutor in several high-profile cases. Devinder Pal Singh Ji, it was not easy to make you write this book. And I think General Sahni, who has a special affection and regard for you, I think you wrote it for him really. General Sahni has just had a eye operation and he was unable to come for today, and he told me this morning that he will not be able to come. But at 3:45, Devinder Pal Singh Ji called him, and he is here at a notice of 15 minutes, all the way from Gurgaon. So that is the regard which we hold Devinder Pal Singh Ji, and I think thank you very much for really writing this book. The book will be released today, and he will speak at length on the book and the criminal justice system generally. But when I read the book, and which was essentially in the early stages, the draft stage, I came away with this impression that it is very important that our experienced advocates and those who are involved in the system, they should write simply, lucidly, and in a manner which is understandable to the ordinary persons. And I think the book does justice to that. But the unique point of the book, as I read it, is that it's very succinct, very direct, and it doesn't beat around the bush. It identifies 9 stakeholders, primary stakeholders who are involved in any case, from investigation to pre-trial to trial and also post-trial, and which goes on to media, etc. So I think in this book, he looks at the criminal justice system as seen from different angles. And that is, I think, a strong point of the book. And in the process of this discussion and analysis, which is there in the book, he looks at the entire, all aspects of the existing legal framework in India and highlights the several shortcomings which are there in the system. The experience of those who are involved in a criminal trial or this whole process is, to say the least, is traumatic. And I think it comes out quite clearly in the book also. In the end, the author also gives several suggestions as to how to improve the system and improve its health. I think one impression that I have after reading the book is that, in this hall we have had, I don't know, dozens of talks in which you talked about the rise of India, the greatness of India in different fields and what we should be doing, etc. But as India rises, I am left with that impression, distinct impression after reading the book, that unless we reform the criminal justice system, our rise will be hollow. There is something called the rule of law. Of course, we have the rule of law in this country, but the rule of law has to be implemented through various institutions and so on. And there are many shortcomings. And as India grows, the rule of law, particularly in the criminal justice system, is perhaps shrinking. And this is something which comes out clearly in the book. And it's our responsibility to make sure that we improve the criminal justice system. Of course, in the past, and Rajiv Jain ji is here, he has dealt with it from the Home Ministry for a very long time. We have discussed the Malyamat committee reports to improve the criminal justice system. This is one of many. Several suggestions have been made and they've been there on the table for a very long time, but nothing much has been done. The most experienced of legal luminaries has talked about how to reform the system, but that has not happened. In the process, I think all those who are involved in this, or as citizens, we suffer. So this book, I think, is an effort in that direction. And it's not written in an academic way, but it's based on the personal experiences of a lawyer who has been intimately involved with it as a lawyer for the last 30 years. So I think it will be a very useful book. So thank you very much for joining us today. So what we'll do is that we'll first formally release the book, and then I will request DP Singh ji to talk about the book and give a talk, which is the Vimarsh talk today. And then we'll have a Q&A, and then we'll close the session. I would also like to invite Senior Advocate Shri Chimaji to the stage to join us in this release of the function. I forgot to introduce you. Please join us also. The publisher, he has done a great job in publishing the book at a very short notice, Mr. Arya.
These were, I welcome everybody. My guru, Mr. R.S. Chima, Mr. Director, Mr. Arvind Gupta, all distinguished members, my friends from law, my friends in life, ladies and gentlemen. We tried to have some guests, a chief guest. I tried my best. Due to the vacations and for illness or for whatever reasons and for vacations, that was not become possible, but then it was a boon. Instead of one chief guest, now I have many. You all are my chief guests for the day. And usually, you will have to bear with me for some time because I want to share my journey and which culminated into writing this book. This book, for a person like me and my friends would understand and they are surprised that I am an author of a book. I'm an author itself is a surprise to everybody who knows me. The first thing that Mr. Chima told me when I joined his office was, okay, you have to learn both languages. Your Hindi is as bad as your English. Or your English is as bad as Hindi. I was poor in languages. I happen to be poor in languages. I have gathered due to some experience during the way, I have gathered that courage to write a book. And that credit goes because in those meetings, a lawyer knows how to speak. Speak his mind out. If we can impress judges, we can certainly impress people who don't know law. And I'm the only lawyer in Vivekananda International Foundation who has been given an entry. So it was an easy job for me. But little did I know, then they wanted me to write these thoughts in a book. Now I tried for a year, 2 years not to do it. But then Sani Saab, General Sani was absolutely, he would not waver. He says, kuch to likho, kuch to likho.
Relentless.
Relentless. And then Mr. Arvind Gupta, Dr. Arvind Gupta and Ambassador Satish Chandra joined him. So I had no option but to say, okay, I will. For a few months, I tried how to go about it. I had no idea. Not because I could not write it. Also no idea because I don't even read books. So I now understand where I come from because that is so important when you will receive this book, that not only that I don't read it, and with my deficiencies and my limitations in my language, I was at pains to know how to write it, what to write it. And one day, I just made who are the stakeholders of this justice system? And that was the starting point because we are not clear who all are the stakeholders. Most of us don't know that we are also stakeholders of a criminal justice system. And that is where I pointed out that these are the stakeholders. Let me define who are they, what is their role, what is their importance. And then it was simple. What is investigation in general life? And I decided that it will not be a reference book. It will be a book for masses. But then it should have something for the practitioners, something for the law students, and something for the judges and policemen. I'm sure, with some experience, that it will have something to think about for every stakeholder. It will at least have a thinking cap on everybody. I have also tried not to give my experiences. And the reason for that was that they were my experiences. The book is my experience, so I'd say that it is my experience, it is limited to that. Every person who reads it will add to it their experiences, their thought process, their way forward, their deficiencies, and how they can be corrected. So I want everybody while reading to have their experiences put in and read it accordingly. The only place in the book where there is some reference is only to show how the bail jurisprudence have been independence and after, especially after post-independence at different decades, the bail jurisprudence has changed. It is again changing in last 2-3 years for the good for the first time. I don't know till how far it will remain because there are some laws where there needs a correction, but I'll deal with it. So when the book was written for BIS, I made it my experience. I took that liberty that even though I'm writing a general book, but I sought permission. Can I sit on my experiences? And I was allowed that liberty. Now to explain the book, I want to go back to my journey, who most of you have shared some bit, some part of it. I could not clear my civil services, and that was the reason that I did my law. My failure was the reason because law was not my first choice. But when I finished my law, I was the president law faculty, and that year happened to be a year of the anti-Mandal movement, and I was sucked into it as one of the leaders. Wasted the entire year, not even knowing what I was doing. Most of people were there without really knowing what they were protesting for, but they were protesting. It was perhaps one of the student protests, and student protests are like that they start with some purpose, but then they do not know what is the final destination and why they are doing it. I was one of them. But when I could not qualify, one thing that was happening was I was going to Mr. T.C. Mathur's office because his son was my friend. So that was an uncle office for me. So I had the liberty to go at any point in time. There were some distinguished juniors. Now they are distinguished lawyers. Rebecca is right now sitting one of them. Sushil Bajaj, Satish Tamta. We have lost a few, Ms. Grover and Satish, Mr. Mathur, Dinesh Mathur, DK Mathur, sorry. And They were the ones who always used to say, "Kuch nahi ho jayega, even if you don't do it. This is a profession." And with the aggressive nature of Mr. Mathur in the court and all those flair and otherwise, that helped me imbibe that shock when I could not clear my civil services. I know I have something in hand and I will do something. That failure did not bother me. And I happened to have been wasted. All my friends, my classmates had already started having the independent office, buying some fancy BMWs and all. And I thought, oh, I'm left behind. I don't even have a scooter. And then I decided to go to Chandigarh because we had faith. My father had faith in Mr. J.S. Chima, late Shri J.S. Chima, father of Mr. R.S. Chima. And by force, per force, Mr. R.S. Chima had no choice. I was made to sit in his office. So he gave me a bail draft thinking I've come from Mr. D.C. Mathur's office. I must be aware of something. I made a draft. He argued that bail application in the morning because that is how Chandigarh works. And the first quip was, "तुम तो बिल्कुल कोरे हो." 4 years into my law, and that was the first thing that I am Kora. And it was true. I had no idea because I could not tell him that that was an uncle office where I was only going, sitting, getting confidence or false confidence of one or the other kind. Then, by a cruel fate, in a short time, I lost my wife and my daughter in a car accident. But that was the day I decided I'll work hard. I put my, not 100%, my life into the profession. Whatever hard work I could do. And I wanted to do a lot of things. And then again came the pat from Mr. Chima, language pe dhyan do. Work on your language. Read judgments more than what you are doing. Improve your skills, drafting skills. There was not a day when I was not admonished. And I would wait because it was clear he would admonish once a day. If it happens in the early morning, then the whole day was absolutely stress-free. Ab jo marji karo. But while he was a strict teacher, he was a great friend. He started discussing life. He started discussing with me the social issues. He started discussing the poetry, the books. I was a nobody, and I started to think about a lot of things. Today, if there is something that I can do law and beyond law something, it's only because of him. It is only because of him. I did not know when I joined his office that he was such a big criminal lawyer. And because he was a criminal lawyer and Mr. Mathur also by chance was a criminal lawyer, I did not choose criminal law as a field to practice. It just so happened that Mr. Mathur was a criminal lawyer, Mr. Chima was a criminal lawyer, that I became a criminal lawyer. And then I had great friends. Mr. Sushil Bajaj, on my first day in the office, even when I was not a lawyer, in the sense not a practicing lawyer, gave me $500, ₹5 ki gaddi. I still remember the face and exactly. It was a parole application, and I prepared, and everybody there also used to second as a munshi because there was no munshi for juniors. So you used to file your cases, get it cleared, get the order, all by yourself. Not me, everybody. And that was the first learning. And after that, 3 years down the line, I got my second 1,000 rupees when Mr. Chima wanted to give it to me because my wife was supposed to come and he says, "Ghuma ke la, khana khila ke lana." from there to here is a journey of upheavals, downfalls, my rise at times. And one thing that I've realized is that Mr. Mathur gave me the confidence to face the world. Mr. Chima taught me life. And together, I think I have imbibed it in a manner that I may not have done justice to both of them, but I still have tried to do something in my journey because I had to fend for myself. I did not want to take money from home. So therefore, now starts my journey as a lawyer, and that is why it was necessary that I spend 5 minutes. That where I come from. I come from struggle. I come from hardship. I come from a background where I did not know anything. Forget law, language, or otherwise anything of life. God has been kind that I got opportunities, and till date, I think I have got more than due. That what I was capable of. God has been actually very, very kind. Coming to the book, as a junior counsel, you perhaps are so focused on briefing the senior that you forget the finer nuances, or not forget, you don't even touch them. Therefore, you're always focusing on the research. These are the judgments, these are the facts, and you have your own understanding when you try to tell your senior and he says, sit down. Like sometimes when he is excited also, something has come. So it's a battle of learning, because why my argument was wrong, why he did not hear. And that is important because as a junior counsel, I must tell a lot of people who are assisting counsels to their seniors that focus on what was argued, what was asked, and what was answered. Don't focus on the case itself because you have read it, you have done your research. In the court, focus on what was asked by the judge, what was argued by your senior, and how that question was answered by him. That's the art of learning as a junior. And when you do this, the day you are arguing your own cases, then you understand a lot of other things. Then you understand the finer nuances. Many a times you learn because of your failures in the court. Till date, I think best of the lawyers, when they come out after arguing the cases, they have something or the other that they have missed. I missed this. And that we should, I think, always remain, because we cannot master anything, especially the law. And that learning and that yearning made me think differently every time, because my roles were always changing. As an additional advocate general, when you are in office and you come to know that you are the only criminal lawyer in the entire office who have done criminal work, then the onus is higher in such a big office. And when you are in that office, you realize that there are a dependency of a lot of opinions to be given. And I just picked up those opinions, and I used to do something like 100 plus opinions. And then later I realized that if I start accumulating cases, put them in bundles of that these cases are like this, so they can be a separate category, and categorize them. Perhaps in a day you can do 500 of them. Within 1 month, the entire opinion work was given. My AG was very cooperative, and he agreed with me almost on everything. The onus was bigger on me. But then That made me think, how many false cases can a police register? I can give you an example. In Haryana and Punjab, there were something like, at that time, as I said, the opinion of Haryana alone was about 700 cases where acquittal was recorded, and the state wanted to file an appeal. When I started categorizing them, there were three types of cases. Number one, the FIR would say, this is the man, बाएं कंधे पे झोला था, पुलिस को देख के ये मुड़ गया या बैठ के पेशाब करने लगा या फिर घबरा गया. थ्री थिंग्स. जिस पुलिस स्टेशन में बाएं कंधा था, वो सारे पुलिस स्टेशन में जितने भी केस थे, they were on बाएं कंधा. The FIR was same. The names changed, the quantity changed. I showed the entire thing to my AG. I said, this is happening. We made a note, gave it to the DGP. Little happened, but then that was the reason that I recalled a case that there was one Darshan Singh, a client from Panipat. A police would call him and say, "Kal case banana hai tere pe, NDPS ka." And then he would write a telegram that police is likely to get me in a false case. And then finally he would be acquitted at some stage. And there were 29 cases, and except for the first one, 28 telegrams. The system did not catch it, did not pick it up. And it was going on because he was also made to mix chocolate, Bonvita, and cow dung to make the drug, which was then supposed to be wasted, and the actual drug he was made to sell that by the police itself. We have come a long way. It does not happen today. But then understand the journey of criminal justice. I can give you one more example, and I think then I'll proceed. There was, I don't know whether somebody has noticed, there is something called fashion crimes. When I joined profession, 304B, dowry death cases, were a rage, big cases, big people, and Mr. Chima being a very, very sought after lawyer. So the best of the cases of the people who could afford him, and those cases I was handling along with him. And today I see there is no 343. Has the dowry gone? Dowry remains as they are. Many cases were where the girl could not adjust. Many cases where the girl loved somebody else and was forced to marry. Today, women are far more, independent in saying no to the marriage proposals, in taking their own decision, and that is why you don't see a dowry deaths. Dowry exists, but dowry deaths don't. But today, all of a sudden, the women have started this thing as marital rape. So now, if there is a discord in the family, then marital rapes would increase. The marriage, the sex on the pretext of marriage, rape, that I gave consent only because he wanted to marry. Now he's not marrying. Slowly, the Supreme Court warded that also off. Now that is on the decline. And if you see, there are decades where there are, these fashion crimes, as I say. Today, the builders are the target. So because you don't get justice in RERA, you don't get justice in NCDRC, you don't get justice in the other civil forums. So criminal law. And you will see cheating cases galore. That's the fashion crime today. So having said that there was a dowry death in a case called Jumani. A poor scheduled caste family, all put behind bars. One of their relatives came. It was a case in Jagadri, and that I was doing pro bono, and it was my first trial. So I also was excited that it's a trial, let me do it. The judge was so, dismissive about every argument, about the entire defense evidence, because I came at the defense evidence stage, I led 7 witnesses, and he was dismissive. Oh, what is there? There's a dying declaration, there is this, and he would just not hear more than that. Conviction. All family members, except 3 children, one children became a mental wreck because there was nobody at home. A girl was molested, and the smallest of them was taken to some relative. And Vinod, who was in my office, wrote a wonderful poem on that. I still have it. If you read it, you can cry. Mr. Chima was requested by me because I shifted to Supreme Court by the time the appeal came for hearing. Again, a conviction early because, and I can tell more candidly, there was a law student sitting in the court to observe. And judges were so, I'm sorry, but then judges were so, this thing to cop on that they have to tell the students how the case is, what the case is. And so, it became a test case for that kind of a thing, and the conviction was maintained. Mr. Chima came here, got it admitted, and by the time it came up fresh for hearing in Supreme Court, I had no such sting attached because I was no more in the Advocate General's Office of Haryana. He got an acquittal. And next day, there was a troll. This case is called Jumini Devi, and you can see the troll on social media. How can a conviction of a dowry death be, turned into an acquittal? Those judges in pressure never again heard or gave any acquittal in any other dowry death cases. Understand that I'm trying to tell you the criminal justice system as we experience. Now is the sad part of it. After acquittal, 2 of them were very happy, and that acquittal happened after 11 years of incarceration of the entire family. One family member died in custody, old man. All others was in custody. They came out for the first time after 11 years. And one of the youngest brother, and mind you, this is also a case where husband was not an accused, because he was in Fauj. So he was not there, so it's all right, he was escaped. But the sad part is that the youngest of them came out, he said, "Why have you got us acquittal?" I said, "What do you mean?" He says, "What will I do now? I had no job. I was getting milk in the jail. I had a bed to sleep. I had a shelter. What will I do now? There is nothing." And that is where our system does not retribute us. A common man always asks me, many a times, when you learn from them, and all these issues comes from not only when you are arguing before a judge and he asks us some question, or a policeman when he does something, out of the blue, out of the box, or something stupid, and the lawyers who are not playing the ethical part themselves. And these things then tell you what is the ills in our criminal justice system, and then you are thinking about it. Can you do something about it? And that is when somebody asks, and many times client asks, "Hun ki karange ji?" What will I do now? मेरा तो सब कुछ ही लुट गया. You take his job, they don't know how to get it back. You make him a villain in the entire people whom he knows, the society that he is accustomed to. You make him a villain in general eyes of public. What he faces in prison is the next level because the entire family. Let us understand, when a man goes to custody and he is the earning hand, there is nobody in the family. When a policeman arrests somebody, he does not understand that he is almost crippling the entire family. And when a magistrate says, arrest nahi kiya abhi tak, the policeman says, zarurat nahi thi, paise khaye hain, and they will go and arrest him. The judiciary is one of the reasons why in states somebody would arrest. But then do we retribute him? We don't. If he wants to, a very rich man feels he's escaped it, let us bury that entire thing. Otherwise, they will go in appeal and things like that and write up to the Supreme Court. A poor man does not even have a wherewithal to do it. He has lost everything if he had something, or he is not able to survive, if at all. A policeman itself will bother him. So it will be very difficult for him to survive in that kind of an environment if he wants to go to the court for a retribution. Now, there are areas of concern, and that is why for everything, right from the stakeholders to some of the important part of the investigations, like arrest, the custody, the search and seizure, the warrants, have dealt with something which is usually an everyday affair. The book is not about everything. It is about important facets of investigation, important facets of pre-trial, important facets of trial, and finally the post-trial appellate stage and sentencing. And lastly, I have arrived at 10 recommendations which I think are perhaps most important. Now let us understand them one by one. When I call stakeholders, the press is an important stakeholder. They play their part. Are they fair? The common man who reads that news items is a stakeholder not only because of that, but because of the spirit of law, because the government represents the entire society at large. And therefore, a common man is a stakeholder. Does he do justice? Because every common man believes that news item, believes in the negative news. Let it be there, all newspapers, let them write. Mr. D.P. Singh is the best person, he is nice. There will not be 0.5% takers of that news. But if the news item reads, D.P. Singh is a highly corrupt man, a highly undesirable, highly such and such, and as a news item, you will complete the news item. Because somebody who is unworthy is being described and they would like to know it. So does the common man do justice to themselves? They don't. Does the lawyers do justice? I'm a lawyer. I'm ready to receive the complainant or the accused both at the same time. Whosoever comes first, I'll be there. And my journey will start to win it for him. Sam, Dam, Dand, Ved. Very few lawyers will restrain themselves from doing it. On the contrary, the lawyers will put the entire, in the complaint, कितने लोगों को फंसाना है. And I don't know if this happens now or not, but in earlier days, because in Delhi you don't do a lot of violent cases of murder and others, but in Punjab and Haryana it used to be, who is their main man? So he is the only earning hand. Okay, so the fatal blow will be attributed to the most important person of the family, so that the family is crippled. There are 10 injuries on the person. FIR is written. The sum and substance of the FIR will come later, after the investigation, after the postmortem is done, after the MLR has been prepared. Now we exactly know that there is an injury on the hand, there is an injury on the shoulder, there is an injury on the head, there is an injury here or on the neck, and then they will find कितने लोग हैं इनके पास जिनको फंसाना है. 5 ही हैं जिनके. Okay, then 3 injuries on one injury on somebody, 2 injuries on somebody, and they will distribute it. That is the kind of the sequence that will be made. In one of the cases, which again from our office, was that there was one gunshot and they had to implicate 5 people. So they said 4 people exhorted him, fire at him. He fired at him and he was sentenced. All were sentenced. In appeal also all were sentenced. Now the question is, who is guilty? Are we all not? The judge, the investigator, the lawyer, the prosecutor, everybody. You know that Sahir share देंगे वही जो पाए जिंदगी से हम. We get what we deserve, what we are. And I'm not talking of individuals. I'm talking of us as a whole. We are a part of a criminal justice system, and the fallacies and the deficiency and why it is crumbling is because of all of us. We all are responsible for its failure. The ethical and moral values of the society are compromised. We all don't stand. And let me tell, I start with myself. I am not fair most of the times because I am representing a client. But for my learnings from my 2 seniors, one thing I've learned is not to lie on law. कि law में boss कभी क्वेश्चन पूछ ले, अगर आपके खिलाफ है, you speak. I have maintained that one thing, but then as a lawyer, nobody will come to you. So I am fair? No, I'm not. And more I learned, the more I have gone ahead in my life, the more people think I am a better lawyer. I personally feel I don't know law much. Because the entire criminal law is based on social values, social behavior. There are different stratas. There's a poor man, there's a very rich man. There's a regional differences, religion differences, cultural differences. We have one law. We have the investigators from different status. In our times, Mr. Pyara Singh was a senior advocate. Mr. P.S. Maan, very distinguished man. Once he told me, I was sitting, "Ki case hai tera?" I said, "Sir, चोरी दा है, वो कहना फिर तो ठीक कोर्ट है, बेल मिल जाएगी. And I asked him later on, because I got bail, sir, how do you know? Oh, Jain Saab the court se they understand finances, he would know that this is not a good case. These are accounting problems. It is not cheating. Mega, but anybody else also would understand. Na kanda je koi Sandhu Saab hunde ya Lohsa Saab hunde kende चोरी करती, पैसे खराब करते, ऐसे बड़ा डाटा काम है. That it is a very serious offense. And I said, what if it would have been violent? कहते then जैन साहब ने बेल नहीं देनी सीखी, फिर उन्होंने देनी सीखी. Even on the bench, you have a different, receiving of ideas, of arguments. We all are, that I'm saying, we are part of the society and we carry that part of us, our behavior, our values, both as an investigator, as a lawyer, as a prosecutor, and as a judge. That is our first failure. We fail the system the day when we can't wear a neutral hat. And wearing that neutral hat is the most important thing that I want to bring to in this book. Second part, excess of justice. You carry today, you arrest a industrialist. The top counsels of this country, and not one, because I represent in these cases, all of a sudden a battery of 10 most important or biggest criminal cases with 20, 30 juniors will come on the other side. Poor me and my two associates will be looking at them, ready to oppose. But then there comes a poor man. He will have somebody who does not even, the lawyer will not even understand a criminal law. He does not even, is not even an expert on criminal law. He is defending somebody in criminal cases. And I can bear testimony, and the people in law would realize that in various states, in district, there will be 2 or 3 good criminal lawyers. So they have a capacity to do only few cases. But what will happen to all others? All others, you don't even know somebody from outside will ask him, मैं कर दूंगा, मैं कर दूंगा, मैं कर दूंगा. And then he will go to a typist and bail bana de, because he does not even know how to make a bail. And it is not only related to this. There are 2 reasons of my initial, I will not call a success, but initial being busy was, one was Mr. Chima's office in Chandigarh, but the other was, and most important one was, there was a host of lawyers who would go get cases from districts. On Fridays and Saturdays, they would go to the districts. They will meet district lawyers. They will share the fees, give a part of it to the district lawyer itself, get something for themselves. And about a year or 2 down the line, I realized that if I ask them, कि मैं कर दूंगा इसको, so they will be happily give it to me. I'll say I'll not take fees. I would draft it. They will get it typed, file it. I will go and argue it. And it was going on. And that made me busy. That gave my first, because Mr. Chima's client would not engage me. Mr. Mathu's client would not engage me. They will not allow a rank junior to argue their cases. The only way I could argue these cases was if I could argue free, coming out of various other lawyers who were not ready to put that labor, but I was happy to do it. And I started arguing those cases independently, and that made me understand the nuances of law better. That made me have my own office in very quick time. And I must say that I had to, to some extent, with a lot of difficulty, separate myself from Mr. Chima because I was so accustomed to him, to those talks. But when I separated myself, the entire day I used to be telling him after my cases, only to have some gems from him in the corridors. Back in Delhi, I had another strength that I could come. I have an office. If somebody had to meet me in Delhi, Mr. Mathur's office was my office. He always maintained that till date, that remains my office. I can still barge in and behave like it is my office. Even when I came here, I spent my initial months in that office only. Now comes the part. Those cases I could do. But what about such lawyers doing cases which they don't have any domain knowledge? They have no way to even address the court. And we have all seen that there are lawyers sometimes they don't even address. So it was up to a judge. A good judge might read himself and try to give relief. Or they would say, my lord, same case. In one of the cases, he could not even say, my lord, what is the case? He says, same as. He says, which case? He says, same. So judge had to ask somebody else, please tell me what is same. So he asked, he said, ye case mein bhi to mila tha. So he said, my lord, he is seeking parity. But he could not tell that. But funny thing is, he also has a place in law. He has a place, and that is where the problem is. Who have an excess of justice. Now comes the downside of it. I practice in Supreme Court also. Now this is a unique country where not one judge in Supreme Court has ever done a defense trial. To my knowledge, I may be wrong, but I think there is not a single judge in Supreme Court who has done a. And a lot of judges would ask me a question. You did not ask this question in your cross-examination. I said, my lord, it was not required. Why? It would have cleared the matter. I said, my lord, the onus was on prosecution, but still you could have exercised it. Now, who will tell him? If that is the Supreme Court of this country, who does not understand criminal law. We are from that country. And you expect it to be a robust criminal justice system. You rarely have judges. And that is why these days you find a lot of judges in Delhi, especially district courts, who are bold, ready to give you relief. Are they sufficient? No. So it is your luck before which judge your trial is going on, before which judge you are. We have a fair ground, equal, fair play. No, we don't have. Now I give different examples. Arrest is the first thing that after registration of a case somebody would do. Yes. Imagine a scenario. The arrest is to be made when there is a justification. There is a Supreme Court judgment right in 1984, Joginder Vimarsh. It says succinctly that one thing is power of arrest is one thing, justification is another. I am a lawyer with 33 years. Not single judge has asked for the justification of arrest. Exceptions only prove the rule. And we argue every time. That is one of my favorite judgments when I take. There's absolutely total disregard. A magistrate will not ask a question, what was the justification of arrest? Because 80% of the times, justification will not be there. Because without arresting also, you could have investigated the case, you could have prosecuted and having a trial. Now, I see it from a very different scenario, and that is there in the book. One arrest means a investigating officer with his team will go arrest him and prepare a memo. His family will be told, that family will run first there, then that family will run to the lawyer, investigator will run to the doctor for getting him examined. Thereafter, he will come to a magistrate. A magistrate will be summoned into picture. He will a lawyer, a prosecutor, the family members, and then custody given for 2 days, 1 day, again brought. There starts this system of bail. The number of man hours of this nation are wasted. One arrest wastes more than 1,000 man hours. Have we ever understood the implication of arrest? Has any judge, magistrate, lawyer, common man, investigator, a policeman have understood what they are doing to this nation by making one arrest? Those are our man hours. Those are nation building man hours. We are wasting it, and the amount of money goes into it. And at the same time, a prosecutor would have done something else. A judge could have written his judgment or attended to other cases. An investigator would have investigated his case rather than having these processes. And worst, the process goes on, bails are not granted, they will come to the High Court, Sessions High Court. Now I have not understood. High Court will first listen on the notice. Then they issue notice or dismiss it. But if they issue notice, on the next date, the man would argue again the same thing. If you have issued notice, you have heard him, hear the other side, what is the justification of arrest? No. Again, there is no argument on the justification of arrest. It is my role is this. These are the tests, these are the bail rules, these are the bail procedures, these are the judgments, these are the processes. Please grant bail. Or other person will say he does not satisfy these. He can influence all those things, or it's a serious crime. And prosecutors like me will say, my Lord, it is a case of so many crores, or it is a case of murder. What is his role? What is his, how much has he done? Even if it's a bungling case, sometimes you have the lowest man who has not even bungled 100 rupees in that 100 crores, multi-crore scam. But he will be arrested first. The state is not. The directors are not. The promoters are not. In so many cases of mine, the promoters are abroad, run away. Everybody who was a new man was arrested and granted bail at later stages. I am a part of that system. But that is what the system in India is. Do we need to correct it? So this book will give ways. And one of the very strong recommendation is, first, don't arrest. Unless it is justified. Somebody can run away, somebody can influence witness. Or, if arrested, grant him bail. The incarceration of bail should not be there. Bail should be, liberal in bail and stricter in sentence. What we do, people who are from Supreme Court and High Court, they will realize that after 10 years, the bail appeal will come and the judge will say, undergone. How much have you undergone? Thereafter, he will ask, 1 year, my lord. Okay, no, undergone. So it is good that you can grant him 1 year of sentence at that stage. Why? Because 90% of times, that, it was perhaps either because it was not a good conviction and you have an easier way out. A lawyer has an easier way out. He doesn't have to argue. And more importantly, the judge has disposed of the case. We are in the business of disposal of cases, not dispensation of justice. We all are doing our jobs. The lawyer does his job. The investigator does his job. The judge does his job. There are few who I have immense respect. They are somewhere, driven by, but they are only exceptions. There are some lovely investigators. I have come across in CBI some of the very fine investigators. And I respect CBI because amongst all agencies, I have a regard for CBI that at least it may not be 100% fair, but it is largely fair. The arrests are also rare. And you have some of the best people. There is an option that a investigator can differ from his senior, a senior can differ from his investigator. Otherwise, every registration of FIR would mean that it has to be taken to a logical end of filing a challan. In states, it is done in particular where you are bound to file challans. Challan is a charge sheet that you are supposed to suffer a trial. And that is where, CBI, at least in many cases, can say, we are not prosecuting. I mean, no cases made out. They also register their PEs, and many cases in PEs are themselves are also, not registered. But again, think where we are, because this is again an exception. In this vast country, you go down and you take out data. I will not go that far. I've tried to show the entire system in the best possible light. The criticism is to the minimal because I focused on the solutions. It is easy to criticize. It is easy to criticize. Very difficult to give a solution. I have tried and given a way forward. Do this. And perhaps it will help us. It's just a way of correcting something. Sometimes the processes have to be strong. Like, suppose there is a complainant. And complainants, we are all, when we say we are victims, the so-called victim will exaggerate the case. If there is one person involved, he'll involve three. Is that not violence? Is he doing more harm than what happened to him? In many cases, yes. There are victims, especially women. They don't even come forward. In this country, the real victims don't come forward. The ones who are smart, and rarely some of the real victims do come forward. But mostly are the ones who are, who want to wreak vengeance. They come. For example, rape cases, most of them are not rape cases. Actual rape cases don't come. But the conviction is the highest in rape cases. Because there's a fear of social, revolt. There's a fear of ridicule in press. Oh, we are so liberal. There are women groups who will come. I remember I was still I was not a complete lawyer in that sense, that there was a dowry death case which was argued for the DP of Justice Y.K. Sabharwal. Rani Jetmani was representing the accused. Mr. Mathur was for the accused. Bail was granted, and there was a huge uproar in the court by at least 50 women who were present there. I'm not naming the case. But then that is how victims also are not fair. They would exaggerate. And then what will happen is a judge would go only by oral evidence. He says this is sufficient. Now we don't have complete data. Many a times it is. Many a times it is not. Do you have a way to do it? Verify which one is right and which one is not? Perhaps not. So how do you call out a judge? He's right. He does not know who is stating right because he is going strictly by the evidence. If at the stage of a trial, a judge would write down, make his notes with regard to the demeanor of the witness. He makes his own observations after every witness. Maybe things can change. Not only for himself, his succeeding judge, but also in the appellate stage. It can help in the demeanor of the lawyer, and then recently, or CBI perhaps may not do it, but they also do it. Suppose there are 10 witnesses, eyewitnesses. Every eyewitness invariably, name change will say the same thing. Now, how can somebody narrate in 161 the same thing? Word by word, line by line, it is same. Does any judge make a note against an investigator that this is a false investigation? I am not satisfied. Everybody is making the same statement. How can word by word be same? Invariably, it is same. There are times when an investigator knows that this is an offense which is ghastly, which is true, and he goes overboard because he wants justice for the victim or he wants to solve that case. It's a true case. But then these cases are exceptions, which means in majority cases, there is not sufficient evidence. But those people are made to say, like a parrot, the same statements. And the court says his statement is corroborated by 2 others, 3 others, and there is corroboration. Why should we not believe? The defense evidence is not given the weightage, though the Supreme Court says defense evidence and prosecution evidence have equal weightage. But the lawyer friends here would know no judge gives equal weightage to the defense evidence. So where is the problem? The problem is in execution. The problem is not with the process. The same CRPC and Evidence Act is working well with England, not with us. There, in one of the cases I saw, somebody would say, I saw this man going inside the building. And that is all, because he has seen only that. Another witness would say, I was in this building, I was, standing in my balcony, I saw this man in that balcony, in that adjoining, in the window. And that would be a circumstance that this man was there. It's sufficient. Conviction can be, rest assured. You don't have to really make 10 witnesses. You don't have to tell every witness that I saw him going up, I followed him and I rang the bell and went inside. And he came running out. And we will make a story out of it. Will not maintain something, the sanctity of something which is in fact a fact. Will distort the facts. So I proposed that during the trial, a judge should have an onus to, in the same trial, arrive at a conclusion whether this complainant was true. Is there a false implication or a over implication? Was the investigator right? And if it is not, and if he is a victim, the accused is a victim, the investigation is false or the complainant was untrue, then have a charge framed, give them a small opportunity to explain, because otherwise evidence has come. If that one thing happens, it will change the entire dimensions of criminal justice system in India. An investigator will think twice. A complainant will not over implicate. He will also have the same danger if he knows I can be punished with the same offense, same sentencing. That is maybe a too revolutionary an idea, but then that is an idea. A nation can be built on good policing. We don't understand even what police goes through. Let me now come in defense and criticism of the police, because they are an important part of criminal justice system. A policeman, as constable on the road, is supposed to pick up, if suppose there is a dead animal, he is supposed to take it. He has absolutely no way to give. So he will stop a rickshawala or somebody, say, dalo, leke jao. And he will do it. He will not get money for it. He has done a job which he was not interested in. He has forced somebody to do that job with him without money. He realizes the power of this. And he is made to do these kind of things every day. Without any infrastructure, without any conveyance, without any infrastructure, he is made to do all those things. A policeman, the SHO is on a job 24 hours by 7. They may have their own excesses, there may be deficiencies in their working, but the system means that he is on the job 24 by 7. When he goes home, he might have to come immediately thereafter. Similarly, there are policemen without any rewards, they work relentlessly. And because there is nobody to take care of their families, their education, they are paid sufficiently low. They're not the highest paid, and they should be the highest paid people in the country if you want a good nation, good police, and complete good rest, good place to stay, good education for their children. Perhaps things might change. But then they work in a system, in the conditions which are not too, inspiring. Where will they get their inspiration to do good work? SP and above, they are dependent on the, whatever is provided, input is provided. They don't meet witnesses. They don't go, they will realize and they will, and beyond a point, they also give up that whatever has come, has come. But then when there is something, the entire top brass comes into action, and, that is why we still can sleep. And we can sleep properly because of the police of this country. There may be deficiencies, but then. So, there is another category. I know I go overboard. I have not prepared a written this thing. But let me quickly now, say what few things that I would like are important, and that is, there is no category of suspect in our system. We call somebody, we suspect him, but we still will call him as a witness or an accused. There is no third thing. And I proposed that whenever you have to give notice to somebody, you have to write it, not only you are a witness, so that he is convinced, I am a witness, I have to go, I have to assist. He doesn't go to the lawyer first. Sometimes even a witness is applied anticipatory bails to the court. Then the court says, no, we don't arrest, need him arrest, and the time will be given, and they will only be a witness. Sometimes they will not even be a witness. Then 91 notices go without telling what do you want. Why can't we write in 91 notices or in a summon notice that, look, this is the kind of case, this is what we are looking forward, that you have to explain it to us. So that even if he has to come prepared, let him come prepared, let him get documents, whatever necessary to assist the police to the investigation. We don't do that. We just send 91 notice or notice to come and appear under 160. We don't describe and suspect. If it is told, it should be told whether this notice is under 41A, we are not going to arrest, or we will not arrest, but we are under a suspicion, you are a suspect. Let him come accordingly so that he doesn't make a statement against himself. So that he understands that, let me not state some of the things which can be incriminatory, which can incriminate him, because there is a protection both under CRPC under 161(2) and under Article 20. Then the registration of cases is one thing where we are forced to, by some of the pronouncement of the court, we are forced to register a case. If some, even though it is still not done in many cases, but still the law is that if a cognizable offense in the narration is brought, do it. We don't have a system of PE as in CBI in the local police, but that should be granted, because the policeman would know many times he would patch up, there would be settlement, and FIR will not be recorded. There are cases where there is a general discord. In all those cases, it can be handled at the police level with the help of community intervention, and they can be solved. And police used to do it. But we have made a law because generally we feel that the police is discriminatory, and they are responsible for that discrimination because they have not done fair registration many a times. So the law has come registering all cases. And once registration is done, then our police is not equipped to give them a clean sheet. Then they have to take it to a logical conclusion. So, there's a blip. There are places where the Supreme Court need to revisit their judgments. And one thing that Supreme Court should also do is let there be constitutional benches on important aspects. Let's say bail. Let's say notices on suspect, on some unimportant facets, and deliver their processes and judgments that follow it, and don't bring us these cases otherwise. Let the Supreme Court of India not get into bail except if those principles where has been laid down by the Supreme Court has been violated, and then there should be a repercussion to it. There should be somebody should be taken to task for having violated the essence or the spirit laid down by the Supreme Court. Trials go endless. I have been a prosecutor in the most important cases of this country. In last 7 years, I have not started a single trial. There are some cases which are pending since 2013 FIR. We have not started the case. 2015 FIR, we have not started the case. Who's responsible? Police? No. Sometimes, yes. But on small aspects, the cases are taken to the higher court, stayed, or they are pending. And the judges are giving long dates. I'm digressing a little bit. Since summary trial and summon trial, which should happen in a very quick time. That's the very essence of criminal justice system and CRPC. But then the date itself is given of the next year. In 138, now things are coming to this. Otherwise, there used to be a date of 1 year. The trial is supposed to finish in 3 months or in quick time. So, speeding the trials and the pre-trial processes. My worst thing is that there are 2-3 trials that I'm wanting to start. But pre-trial processes that this document was not given, these underlying documents are there or not there, this has to be given. There is almost a pre-trial before, only those processes to be executed, documents have to be given. Therefore, we need to simplify, hasten those processes. Sentencing is this. I'm trying to quickly wind up. I'm sorry, I've gone overboard. 361 and Probation of Offenders Act says, give chance to people, grant probation. In some cases where sentence is less than 7 years, and for some categories, even if it is more, up to life, you have to give reasons why you're not giving a probation. The arguments on sentence rarely happens. Very few lawyers do argue on sentencing. Very few judges hear them on sentencing. It would be a big exception if there is a judgment. At least I, in 33 years, have no judgment where a judge would give reason why he is not giving a probation, even if it is when it is argued. Probation of Offenders Act and the CRPC 360 and 361 have been made redundant. Give reasons, exercise it. A lot of people will not go to jails. I'm not going to the jurisprudence because that was not part of the criminal justice system, because that's an absolutely reformatory system. I've not dealt with that, though they are part of the criminal justice system for reformation. I've said that. I've dealt in brief. But the conditions in jail and jail world is a different world altogether. So sentencing, I have suggested, please don't incarcerate people, grant them bail, be strict in sentencing, but also into the probationary aspect, where a person is the first offender, where a person is likely to jail, where the person is likely to show remorse, where a person is likely to settle as a very good human being. Because most of us, when these cases happen, are either in the fit of anger, or they are not those big cases where somebody would do it again and again. And if somebody does it again, then you have you can give a higher sentence. There is a provision for that. Therefore, people, I'm leaving the scientific investigation part of it because, with all that AI and technology, scientific investigation should be more and more. We are utilizing it, but only with regard to cell phones, locations. It helps. But then there is more to scientific investigation which we need to look into. I'll not dwell much into it because I would like some interaction. Some of my best friends are policemen. Some of my best friends are judges. And a big list of my friends are lawyers. Believe me, individually, they also want reform the system. I think it's just that we have not made a collective effort. One thing is that we can pick ourselves up. Let us join hands, let us make a group society and do something for the reformation of the criminal justice system. There are people amongst these where I don't have to touch somebody's feet. I just naturally go and touch their feet because they deserve that. And they're from all strata of society. Yet they are all humans, and they are also not doing sufficient in making this effort on the side, which is beyond their call of duty, to write, to appear, to have conferences, to have a idea sharing platform, to make a group, to do something or to change things. Let us all come together. This is a very small beginning. It is my experience, humble one. It may not be too profound. At least I made an endeavor. Pardon me if you feel that there is something which is not correct, there is something which is lacking, there is something which is deficient. We can all contribute, adding to this and otherwise. Thank you very much.
Thank you. Mr. D.P. Singh, you would all agree, has spoken from the heart, and he has pulled no punches. I think he's been very honest in his presentation and in his ideas. And he's made several recommendations, 10 recommendations, and I'll just read out the last one, which to my mind is the most important. Investigators, lawyers, and judges must practice self-discipline and maintain high moral and ethical standards. I think everything flows from there. So that's a very important thing, but the plea for reforming the criminal justice system is very timely. And I think all of you, probably most of you are from that profession, because I see so many new faces today here. And you would take this home, but I think even for those who are not in the profession, you have made a very touching presentation. So thank you very much. So we have some time. We'll take a few questions, but let's be very brief, no long prefaces, so that you can. We'll take 3 or 4 questions, then you can answer, and then we'll follow up, because we don't have too much time. Yes, please. Kindly introduce yourself also, Sir.